so say this happened, and I'm like being so specific because this literally happened to me, where I had started under the name originally Podcasting Made Easy. And then 4 episodes in, like launch episodes, I get this email, the cease and desist email from someone. And so he was like, oh, no, this is my trademark. I have filed a trademark and I don't want to have to take you to court. So like this is a pre-cease and desist email. Now, like years later, it's kind of like, I feel like there's so much more blur, like there was way more opportunity for me. Like I had much more of a stronger claim to it than he was saying that I did, because he had sold like maybe 6 courses with the title Podcasting Made Easy. So he was saying, because I have first in use and I have documentation and there was payment in exchanged, that's why I have a stronger claim, which may very well be the fact, but I wasn't trying to do that. I was just like, it was just the title of my podcast.
Yeah, so there's a couple things going on here. And so first, I think that it's so important for podcasters and really for any small business owner to understand that cease and desist letters do not have legal authority. And so when the business owner gets a cease and desist, I know the first, like, you get that like pit in your stomach feeling, like it's just not a good feeling to get a cease and desist. But what a lot of people don't know is that a cease and desist all by itself does not have legal authority. And in fact, many cease and desist letters are bluffs. They are bold-faced bluffs. And the person who sends it has zero intention of ever doing anything about it. Now, I don't want to be misunderstood. I'm not saying that cease and desist letters should be ignored because a cease and desist letter is usually the first step to litigation in trademark law. So I'm not saying that they should be ignored, but just making the point that it's a letter. Like it truly is a letter, and that letter by itself does not have legal force. Now, when we're talking about a situation where, I think my earlier example, I was assuming a situation where both parties have registrations. Now, let's take a step away from that to this situation where neither party has a registration. That, like you said, can be a gray area because if a trademark isn't registered, then it's just a common law trademark. And a common law trademark is only protected in its geographic area. So you can have a situation where maybe there's a Podcasting Made Easy in Virginia, and then there's a Podcasting Made Easy in California. Neither of them are registered, so they're both just common law, which means that it's probably fine because one gets to own Virginia and one gets to own the territory of California.